Hi, everyone, and thank you very much for joining us today for our presentation on the EB-5 Investor Green Card or Immigrant Visa. My name is Dustin Saldarriaga. I am a Senior Associate with Scott Legal PC in New York City. While our firm does focus on business visas, such as the EB-5, we do handle the full spectrum of U.S. immigration law, whether that's student visas, temporary visitor visas, temporary business visas, family-based green cards, or employment-based green cards. We'd be happy to help, so don't hesitate to reach out to us. And our approach is really defined by the fact that our firm's founder, Ian Scott, has personally navigated the immigration process on an F1 visa, a TN visa, an H-1B visa, and an E-2 visa, which is the visa that he used to establish our firm. So really our approach is defined by having navigated the process ourselves. A few housekeeping items before we get started with this presentation. We do try to do at least 2 webinars a week, and those are on, again, a variety of immigration topics. We do hope that you will sign up for future webinars on whatever topic is relevant to you. After this presentation, we'll send you an email with a link where you can sign up for those future webinars, as well as a link to our YouTube channel. We are very proud to have an active and very informative YouTube channel. We put a lot of effort into our videos. We hope that they are informative. We have both short format videos on a variety of topics, as well as the recordings of our full-length webinars. So this webinar is being recorded and will be posted to our YouTube channel once it is complete. If you have any questions, I do plan to get to all of the questions by the end of the presentation. Please do feel free to send in any questions using either the chat function on Zoom or the question and answer function on Zoom. And yes, one final note, we will be sharing with you the PowerPoint presentation you see on your screen, as well as a comprehensive guide to the EB-5 green card. So hopefully that will help you to not have to take as many notes during the presentation. Without further ado, let's go ahead and get started by talking about one of the fundamental distinctions in the EB-5 program. So the EB-5 green card or immigrant visa is an option for permanent residence in the United States. Why do I call it both a green card and an immigrant visa? So basically, you can pursue the EB-5 visa from within the United States or from outside the United States. If you get it at a consulate outside the United States, you're getting an immigrant visa that allows you to enter the US, and then once you enter the US, you receive the green card in the mail. If you're inside the US, you would apply for an adjustment of status through USCIS and receive a green card in the mail as well through that process. So this is a permanent residence option. It is an immigrant visa that if you do decide to ultimately pursue citizenship, this will offer you a path toward that. Now, the EB-5 visa is referred to as a job creation green card. And that is because job creation is fundamental to the EB-5. You have to show that you'll create jobs from your investment. When people usually think about the EB-5, they think about that investment piece, because the EB-5, to qualify it, you do have to invest a significant amount of money. That's either going to be $1,050,000 or $800,000, and we'll talk about that distinction. But that investment is required, and then the job creation has to follow from that. So those are the requirements that apply to any EB-5 application. But there are two different pathways within the EB-5 green card world. The first pathway is the regional center pathway, and the second pathway is the standalone investor or direct investment pathway. So the two broad ways to think about this are the regional center option is a wonderful option for those who are looking for a more passive EB-5 route. What is a regional center? So a regional center tends to be a very large project. It could be building a shopping mall. It could be building a new metro station. It could be a hotel or a resort. So we're talking projects that cost tens of millions, if not hundreds of millions of dollars. And so dozens of EB-5 investors can apply under a single regional center because each EB-5 investor is going to be investing at least $800,000. So you could have dozens that contribute to that regional center that may require tens of millions or hundreds of millions of dollars. So a regional center, importantly, can support more than one EB-5 investor. Again, fairly passive. You tend not to have an active role in a regional center. You're not voting to make decisions on how the shopping mall is built or things like that. You are typically listed as a limited partner of the project, but you have minimal say, minimal active role in the actual operations or building of the regional center. There are high administrative fees for regional centers. So typically these run in the realm of about $50,000 that will be paid to the regional center. There is a reason for this. It does take significant effort to apply for and be approved as a regional center. Also, the regional center typically will gather much of the documentation that's required for an EB-5 application in terms of the project itself and the job creation. So they oftentimes will have economic reports showing how many jobs will be created from the project, and they will share those with you. You will not, generally speaking, will not have to create those yourself. You do have to, we'll talk about this later, you do have to document where you got the money to pay for the administrative fees, as well as your investment amount. There is a risk to regional center projects, so it's very important that you do your due diligence. Find a regional center that has a good reputation. You can learn that from online reviews, from reaching out to different people. We are also happy to talk with you about that, but not all regional centers are created equal. Also, just because a regional center is approved by USCIS does not mean it's a good regional center. So the USCIS is fairly clear about that. So you do need to do your due diligence, even if you're investing in a regional center that's been approved by USCIS. A couple of the key benefits of a regional center. So I would say one of the main benefits is it's passive, so minimal work on your part, assuming you have the cash to invest. Also, regional centers are usually in targeted employment areas. That means that they are eligible, by and large, for the lower $800,000 investment amount. So typically, if you're investing in a regional center, you do not need to invest that $1,050,000. You would invest the $800,000 because, again, regional centers are usually created in a place with high unemployment, or that is in a rural area, and they would typically qualify as a targeted employment area or a TEA. So the other main benefit of a regional center is that indirect jobs do count. So again, you must prove as part of the EB-5 application that you've invested the money and that investment led to the creation of at least 10 jobs for US workers. So those jobs for a regional center can include indirect jobs. What are indirect jobs? Let's take the example of a resort. Let's say that the regional center is the building of a resort. Direct jobs would be W-2 employees of that resort. So that may be the managers of the resort. That might be people working at the front desk of the resort. So people who are employees, they receive a W-2 tax form at the end of the year. Their hours are determined by their employer. They have to wear a uniform, things like that. Indirect jobs would include, for example, contractors. So let's say that to build the resort, a construction company is hired that sends in workers to build the roof, build the walls, all that hard work. Those 1099 independent contractors can count as indirect jobs. There may also be an argument that Jobs that are created from businesses that are built as a result of this resort also count. So let's say that the resort is going to include commercial space where there are going to be some shops on site at the resort. Those jobs might also be counted toward the EB-5 requirement. And so if you have a regional center, again, if you have, say, 100 EB-5 investors, then you need to show at least, the regional center will need to show at least 1,000 direct or indirect jobs. So 1,000 divided by the 100 EB-5 investors leads to 10 employees per investor. So again, each EB-5 investor does need to show at least 10 jobs created from their investment. That's the regional center route. The second route is the standalone investor or direct investment option. So what that is where the EB-5 investor owns and really is the one operating the business. So the example I like to use is, let's say that you have been working very hard on an E2 visa, building a restaurant in the United States, and your restaurant is quite successful. It is um, employing a number of people. You've put a good amount of money into it, and you decide, you know what? I want to continue running my business, and I want my EB-5 investment of $1,050,000 to go into my business. And I will show that my business has then created at least 10 jobs for US workers. That would be a direct investment project. You are the one actively running the business. You also are the only EB-5 investor. So a direct investment or standalone investor option can only support one EB-5 investor. This changed in 2022. So before 2022, you could have more than one EB-5 investor through a standalone project. So that restaurant could have, say, two co-owners who apply. Each one applies for an EB-5. But now, after 2022, you do need to have only one EB-5 investor per direct investment or standalone investor project. If you have more than one EB-5 investor, you do need to register the business as a regional center. And that, again, does take a significant amount of work to do. Can be done, but does take more work. So a direct investment, because it is your own business, it does typically have the potential for a higher return. You're the business owner, so the sky is really the limit. If your restaurant does extremely well, you get to enjoy that return. Only direct jobs are counted, so it would only be direct W-2 employees that are employed by the business. The the other huge benefit of the direct investment option is that this is really the original EB-5 program that was passed by Congress. So this program is quite stable from a legal standpoint. The program does not expire. It continues chugging along. You can continue applying for this program. That is in contrast to the regional center program. So the regional center program is renewed by Congress. It was started in around 1992 as a pilot program, and it is still referred to as a pilot program, even though we're over 30 years later. And so Congress does need to reauthorize the regional center program. And as we saw back in 2021, 2022, the regional center program stalled for about 9 months, if I recall correctly. And so you did have a lot of people who were just waiting, waiting, waiting. The government did no work on regional center applications for 9 months. So that caused a lot of people headaches, concerns. And so the direct investment option does relieve you from that risk. That being said, we'll talk in a few slides about changes that were made to the regional center program that does add some stability to it that wasn't there back when the program stalled in 2021 and 2022. And for the direct investment option, funds that have already been invested in the business can potentially count toward your EB-5 investment. So again, the 10 jobs that are created need to follow from your investment. But if you've already invested in your business and you want to hire more workers, then you can use that investment, even if it happened in the past, toward your EB-5 investment. And we'll talk about an example in a few slides that looks at that. So again, the very broad stroke EB-5 visa requirements that that apply really whether you're applying through a regional center or a standalone or direct investor project and direct investment project are the investment needs to happen, whether that's $800,000 in a targeted employment area or $1,050,000 if not in a targeted employment area. Then jobs need to be created, at least 10 jobs per EB-5 investor. And then basically there's the EB-5 filing. The timing on that is not exactly correct. You can apply for the EB-5. You can file your EB-5 after you have invested the money, but before the jobs are created. So we'll talk about how to do that later in the presentation. So I mentioned that you do have the option. There are two investment options. There is the standard investment amount for an EB-5 is $1,050,000. So that is the standard amount. There is an exception to that though, which is if your business, if you're doing direct investment, or if the regional center is located in an area of high unemployment or a rural area, then it may qualify as a targeted employment area. And if it does, then you can qualify for an EB-5 with a lower investment amount of $800,000. So that can be a significant benefit if you want to save $200,000 on your EB-5 investment. You see the term new commercial enterprise on your screen. What is a new commercial enterprise? So that is the legal term for the EB-5 business. So basically, let's say you're doing a direct investment project. Your new commercial enterprise, sorry, your direct investment project is the restaurant, the example I used before. That restaurant would be the new commercial enterprise. In the law, there is another term for the job creating enterprise. So we call them the NCE for the new commercial enterprise and the JCE for the job creating enterprise. For a standalone or a direct investment project, those are usually the same thing. So the restaurant is going to be the NCE and the restaurant is also going to be creating the jobs. So it's the JCE. Some larger projects and oftentimes regional center projects will have a new commercial enterprise, NCE, that will have a separate legal entity that is actually employing the workers, and that would be the JCE. Not something we need to get into detail on during this presentation, but the important takeaway here is that if you are applying for an EB-5, you should understand what a new commercial enterprise is. That is the EB-5 business. It's a term you're very likely going to hear over the process. It's the EB-5 business. Now, the terminology there can be a little confusing. New commercial enterprise. What if you buy a business that was created in 2010? Can that qualify? Is it new? The answer is yes. So new commercial enterprise, keep in mind that term was passed back in when the EB-5 law was first passed. So this is 20, 30 years ago. Any business that was created after, I think it's 1994, in general, as long as it's a for-profit enterprise, is considered a new commercial enterprise. So if you're looking to buy a business that was created in the 1980s or early 1990s, this might be an issue, but if not, shouldn't be a concern. Which investment can be included? So there are a few things. The investment needs to be your personal funds. So they need to be in your personal possession. That's why retained earnings don't count. Let's say that let's go back to our restaurant example. Let's say your restaurant is doing extremely well and has retained earnings of $1,050,000. Can you just say, well, my business has $1,050,000. I'm now going to hire 10 people and I've got the investment and now I have the employees. EB-5 is all set. You cannot do that because retained earnings are the business's funds. They are not your personal funds. So you would need to distribute those retained earnings to yourself as the business owner. You would need to pay taxes on those funds, and then you would need to put them back into the business and then hire the 10 workers. So you really do need to be careful about the process and documenting every step of the process to show that you use your personal funds to invest into the business, and that then generated 10 jobs, at least 10 jobs. The other thing to know about the investment that can be made is the funds need to have been lawfully acquired. So in other words, you need to prove to the government that the funds were lawfully acquired. And this can be a hurdle, especially if you're using cryptocurrency, because it can oftentimes be very difficult to trace where the cryptocurrency came from. So make sure that whatever funds you are investing in the business, you can document exactly where they came from. It might be a distribution of retained earnings to you. You would document that distribution. It could be that you sold a home, you sold an apartment, you cashed out an investment account, you inherited funds, they were insurance proceeds. You could receive a personal loan from a bank. You could receive gifts from a friend. All of these are valid sources of funds, but the important thing is that you do need to document exactly where the funds came from. And if you are using a loan or a gift from a friend or family member, that friend or family member needs to document where they got those funds from. There really is no easy way around that documentation requirement. So make sure you can show where you got your money from. And many people ask us, what are the differences between the E2 visa and the EB-5 visa? The E2 visa is a temporary visa for people who want to develop and direct a business in the United States. It is not a green card. It also has a far lower documentation requirement than the EB-5, and in general has a lower investment requirement. So the EB-5 has a strict $800,000 or $1,050,000 investment requirement. You're not going to qualify if you invest lower than that amount. The E2 is far more flexible. You have to show that you invested enough to get the business started. So that could be $100,000. That could be $80,000. It could be $1 million if that's what's required for the business. But there's far more flexibility in the E2. Also, the documentation requirement that I mentioned before, showing where the money came from, is far stricter for the EB-5 than the E2. The EB-5, our applications will oftentimes run several hundred, if not 1,000 or more pages. And typically that is because we have to show every single step of the process that the funds followed, from being generated to being invested into the new commercial enterprise and then being spent by the new commercial enterprise to generate these 10 jobs. So the source of funds requirement is quite significant. It is probably the hardest part of an EB-5 application. For the E2, it is also challenging, but oftentimes for an E2, especially if you're applying at a consulate, you only have to generally show that you have the funds that you're investing into the business. So let's say you sold a property. You would include proof that you sold the property, and then you would show that you put those funds into the business. And oftentimes consulates will have a page limit, which does not apply to the EB-5. There is no page limit. The other very important difference between the E2 and EB-5 when we're talking about the investment is that for an EB-5, your investment, the funds need to be made available to the EB-5 business, to the new commercial enterprise. So your funds need to go into the new commercial enterprise. What does that not include? If you find someone who is selling their business for $1,050,000 and they tell you, hey, I have 10 employees. I'll sell you my business for $1,050,000, and then you can apply for an EB-5. And you give that person your $1,050,000. That money has not gone to the EB-5 business. That money has gone to the seller. So those funds are not available to the business to generate jobs. So that is not going to qualify for an EB-5. And E2, you can qualify based on what you've paid to the seller of a business. So if you buy a business and you send your investment amount to the seller for an E2, that could very well qualify for an E2. That will not work for an EB-5. So if you're buying a business on an EB-5, you do need to make sure that if you're paying $1,050,000 to the seller, you need to be prepared to put an additional $1,050,000 into the business that then leads to the employment of 10 additional workers. So the job creation requirement, we were just talking about that. The investment needs to lead to 10 full-time jobs for U.S. workers. So these are permanent residents or U.S. citizens. Direct jobs are required for the standalone or direct investment option. Indirect employees can count for the regional center option, but not for the standalone or direct investment. And again, I've said this a few times, there needs to be a link between the investment and the job creation. So the investment needs to happen before the jobs are created, and those funds need to be used for the creation of those jobs. So oftentimes that will be those funds could be used for payroll. Those funds could be used to purchase additional assets for the business that will expand it or maybe an expanded space, but they need to be used by the business in a way that does build the business and creates the opportunity for additional jobs. So I mentioned before that you don't need to have those 10 jobs filled by the time you apply for an EB-5 green card. So what what would you provide to the government then to satisfy that? You would include in your application a detailed business plan. So um, basically to take a quick look at the process, I'm going to skip ahead here and look at the EB-5 filing piece because I think it's helpful to understand what I'm about to say. An EB-5 green card has three main parts. The first part is you're going to file a Form I-526 with USCIS. So the Form I-526 is basically, it is the first step. And basically what it is showing is it's giving the government information about the new commercial enterprise, how much you've invested, how many jobs you plan to create, and it gives information about you, who you are, what your role at the business will be, if any. If it's a standalone or direct investment, you do need some role, what your ownership share is, things like that. That's the first step. So once the I-526 is decided by the government, by the way, the I-526 in and of itself does not give you any benefits. So it doesn't let you stay in the US. It doesn't give you work authorization. It doesn't give you travel authorization. Doesn't give you a social security number. It is really just the first step for the EB-5 process. But once the government decides the I-526, it will consider your actual green card application. And that's the I-485 if you're inside the US. And if you're outside the US doing consular processing, then it is the DS-260. So that is the application for an immigrant visa, the DS-260, or the I-485 is the adjustment of status application. So your green card application if you're inside the US. The I-485 or DS-260 can only be decided by the government after the I-526 is decided. Now, fortunately, you can submit the I-485 for some categories of applicants. You can submit the I-485 at the same time that you submit the I-526. So that's if you're in the US, you can submit the I-485 at the same time as the I-526, depending on which category of applicant you are. And I'll clarify what that means. That can be a huge benefit because when you file the I-485, even if it's going to take the government years to decide the application, in the meantime, when you file the I-485, you can apply for travel authorization and a work permit. And the government will decide those while the other forms are pending. So let's say you were to file today, and let's say you were to file in the as a TEA, so a high unemployment or a rural area. I'll look up the visa bulletin right now, but I do believe that both of those categories are current. Let me quickly see. And what it means that they are current, it means that the green cards are available. So if USCIS approves your application, a green card is immediately available. So let's look. So yes, so right now, if you apply based on a rural or a high unemployment area, green cards are available. So that means if you're inside the US, you file an I-526 based on a targeted employment area, rural or high unemployment. You can file the I-485 at the same time. It is going to take USCIS about 5 years to decide the I-526. So you're not going to get a decision on your I-485 for 5 years. But you can, at the time you filed that I-526 and I-485, ask for work and travel authorization. That means that 3 to 6 months after you file the application, you will likely have a work permit and a travel permit. That will allow you to apply for a social security number. That will allow you to enter and exit the US freely. So a huge benefit right now. So you're able to work, you're able to travel, and you're just waiting for that I-526 and I-485 to be decided in the background. So the the final stage, so I've now described the first two of the three stages of the EB-5. The first stage is the I-526. Second stage is the I-485 or DS-260. If the I-485 or DS-260 is approved, what you get is a conditional green card. It is a green card that's valid for only 2 years. And at the end of that 2 year period, you need to apply to remove those conditions. That is done by filing a form I-829. The I-829, basically what it is saying to the government is, I've been in conditional permanent resident status for 2 years. My EB-5 business is continuing to do well. I've satisfied the employment requirements. I've satisfied the investment requirements. Now I want my permanent green card. Once the I-829 is approved, you get your permanent green card. Unfortunately, the I-829 is also taking a few years to decide. So you can see how the complete EB-5 process really can take anywhere from typically 5 years to 8 years from submitting the I-526 to actually getting your permanent green card. We do have a quite successful litigation practice at where we sue the government based on what we think are unreasonable delays of the I-526 or the I-829 typically. While past results don't determine future outcomes, we do find that the delays, in our opinion, are certainly unreasonable, and we found that judges do tend to agree with us when we bring those lawsuits. But that all goes to show that the timing of the EB-5 unfortunately is taking a while, but while the green card is current, you can get the visa. That is a huge benefit to being able to apply for the work and travel permission if you're inside the US. So that can be a huge help. In 2022, I mentioned that the regional center program stalled. It stopped operating for about 9 months in 2021 and 2022. So in 2022, Congress passed the EB-5 Reform and Integrity Act. It basically got the regional center program going again, and they implemented a number of important changes. So one, which we've talked about, is that the base investment amount increased to $1,050,000. Also, the TEA investment amount increased. It used to be 500,000, now it's 800,000. The regional center program was reauthorized, as I mentioned, through September 30th, 2027. So the program should not stall before September 30th, 2027. What will happen on September 30th, 2027, I don't know, but hopefully Congress will reauthorize it in time so that it doesn't lapse. Now, Congress did say regional center filings that are filed before September 30th of 2026 will be decided. All right. So what happened last time was, regardless of when you applied, when the program lapsed, the government stopped working on these applications. So Congress passed this law that says if you file your application before September 30th, 2026, we are going to decide your application. So even if the program is not reauthorized, we're going to decide those. So try to get your applications in before September 30th, 2026, if you are thinking about the regional center option. The rules of what a targeted employment area is also changed. So in the past, you could figure out what a targeted employment area is based on census tracts and unemployment rates, and you would basically include that information in your application. Now, the federal government decides what a targeted employment area is. So it does make it harder to qualify for the lower investment amount. If you're going the regional center route, by and large, those programs have already done this. So they've already determined what the TEA is. They're inside the TEA. So regional centers do tend to be in TEAs. So that rule change is generally more relevant if you are going the standalone investor route or the direct investment route. Let's say you have that restaurant and you're trying to qualify as a TEA, it may be more difficult to do that now. The final bullet you see is that there are a number of EB-5 projects that are now set aside. What this means is that the government has said we have a certain number of EB-5 visas. We're going to reserve a certain number of those for EB-5 projects in rural areas, for EB-5 projects in high unemployment areas, and for EB-5 projects that are infrastructure projects. So building a subway station, things like that. This actually, in my opinion, is a significant benefit because what it means is that you can be very deliberate about the type of EB-5 project you apply for and use that to your advantage if you are of a nationality in particular with a long wait time. So the way to figure this out, if you're at your computer, you can Google Visa Bulletin. The most recent one is February 2025, which was recently released. And if you scroll down the tables here, you'll see that in the employment-based category, I'm just going to look at final action dates. In the employment-based category for fifth, you see that in the table there are multiple rows for the fifth category. There's fifth unreserved, there's fifth set aside for rural, fifth set aside for high unemployment, and fifth set aside for infrastructure. And if you look at the top of that table, you'll see a number of countries listed: Philippines, Mexico, India, China, and basically other countries. So if you look at that first fifth category, fifth preference, unreserved, and you look at China, you see the date 15th of July 2016. What that means is that for EB-5 applicants who were born in China, it doesn't matter if they later got Canadian citizenship and now have a Canadian passport. The country of birth is what defines this. So if they were born in China, applied for an EB-5, right now, green cards, immigrant visas are being made available for those who applied in July of 2016, 9 years ago, 8.5 years ago. That is a long wait, and that there is no budging that. You cannot sue to make that go faster because that is Congress that decided how many green cards would be available, and this is based on the line of people from China waiting for those visas. Similarly with India, you see the date is January 1st, 2022. So right now, you're looking at 3 years. People who applied in 2022 are now, they have visas available. So 3 years. Keep in mind that, that again, that is separate from how long it takes USCIS. So even if USCIS decides your I-526, you cannot file the I-485 until your date is current. So for someone who was born in China, if they're inside the US, let's say they're inside the US on an F1 visa, they've been studying for a while, they're getting their PhD, they filed their EB-5 project. If they filed their EB-5 application after 2016, they cannot file the I-485, which means they cannot apply for work and travel authorization. They can only file the I-485 once they have met this date. So you can see how if someone who was born in China is applying today, what they can do is they can either start a business, or if they want to go the standalone investor or direct investment route, or they can find a regional center that exists in a rural area or an area of high unemployment, which is current right now. So visas are available, even for those born in China, if the business is in a high unemployment area or a rural area. That means if you're in the US on an F1 visa, you were born in China, you're investing in a regional center, you can file the I-485 at the same time that you filed the I-526. And you can include work and travel permission, the request for permission in that application. So within 3 to 6 months, typically, you'll have travel authorization and work authorization, even if for another category, those born in China would be waiting 8 years. So huge benefit to use these set aside categories. Um, so a number of the things on this page I've already talked about. As I mentioned, you can file an I-485 concurrently with an I-526. That's what I was just saying. You can also, with the I-485, apply for work authorization and travel authorization. Documentation of the source of funds is the biggest, most difficult part of an EB-5. Usually, you do have to document administrative fees. So that means in addition to the $1,050,000, if you paid $50,000 to your lawyer or to a regional center, or filing fees with the government, you need to show exactly where those funds came from. So typically, you're not looking at just $800,000. You're looking at $850,000. You're looking at not just $1,050,000. You're looking at $1.1 million that you need to document where you got the funds from. Loans and gifts, again, they are permissible, but they need to be loaned or gifted to you personally before they're put into the business, and you do need to document exactly where those funds came from. So if you have a very nice uncle who is gifting you $1,050,000 for your EB-5, he unfortunately is going to need to provide documents showing exactly where he got that money from. And there were certain protections built into the Reform and Integrity Act of 2022. So good faith investors can complete the permanent residence process even if the EB-5 entity or regional center is terminated. There are some conditions and terms to that, but important to keep in mind. And the petitioner may be protected if the regional center program expires in the future. So like I said, 2027, it should be operating until, but if it's not renewed, there may be protections for those who applied under it. Again, that's a fairly nuanced area of law, so I don't plan to get into it much more in this presentation, but you can schedule a consultation if you have questions. What other considerations are worth considering for an EB-5? So the first thing is the investment. Some very common questions we get about the investment. When do I actually need to invest my money? If you look at the law before 2022, there was language regarding the intent to invest, which suggested you could invest the money after you file the I-526. That is far more tenuous after 2022. Our recommendation is that you actually commit the full amount of the money to either the regional center or to your new commercial enterprise for a direct investment project before you file the I-526. It's just the safest thing to do, is to show you personally had the $1,050,000 and you have transferred it to the business. Even if it's just sitting in the business's bank account, that's okay. It doesn't actually have to have been spent on creating the jobs before you file the I-526. But we do recommend that the funds actually be in the hands of the business or the regional center. I already talked about loans and gifts. I also talked about purchasing a business. The funds need to go to the new commercial enterprise, not to the seller. So you do need to satisfy that EB-5 investment requirement, even if you've already paid the seller directly to purchase the business. You want to avoid any wording that suggests that you will receive a guaranteed return on your investment. So, for example, if you are doing the direct investment option and you have that restaurant that I mentioned before, and in the agreement between you and your co-owners, it says that you have a right to get your $1,050,000 back whenever you want, that is going to be a big problem because your investment needs to be at risk, meaning there's a possibility that you'll lose it if the business fails. So the government wants to see you're putting your skin in the game and you are serious about this business. Moving from an E2 to an EB-5, the investment that can count is in general the investment that was yours personally. Again, retained earnings don't count, that you can document, and that was invested in the business before the jobs were created. So, if you have an E2, um, if you have an E2 company that has 20 employees and you invest $1,050,000, you need to create another 10 jobs. You can't rely on the jobs that existed before your investment. Um, and finally, we've talked about buying a business, so I'm not going to mention that again at risk of repeating myself. Um, I do want to save time for questions. We've gotten a couple, but let's quickly go through this case study. So this is an E2 to an EB-5 example. So Helen got an E2 visa in 2015. She purchased shares of a business for $300,000. The business had 5 full-time employees when she purchased the shares. She paid lawyers $40,000 in legal fees. In 2019, she invested another $500,000, which she got as a gift. The person who gave the gift got the money from the sale of property, that they inherited 15 years ago. Instead of giving the money to Helen, they put the money directly into Helen's business bank account. So let's actually take this step by step. So that $500,000 in 2019 is not going to count toward the EB-5. And the reason is the money was not given to her personally. It was sent directly to the EB-5 business. So again, Helen has to she has to hold the funds personally before they are put into the business. So in this case, if someone says, hey, I'm going to give you a gift, but I'm just going to transfer it right to your business, it was never yours. It was the gifters, and then it was the businesses, and that's going to be a problem for an EB-5. When the money was invested, the 500,000, the business had 10 full-time employees. So Helen has hired an additional 5 since she bought the company in 2015. At the end of 2019, she paid herself a bonus of $100,000 after the company made $1 million. Okay, so she has received $100,000 personally. That million is presumably retained earnings. In 2020, she applied for an EB-5, showing a total of 1.8 million invested. She also included information showing that she had created 10 full-time jobs. She plans to hire another 3 to 4 employees, but she's not committed to this. And her business is located in a targeted employment area because the unemployment rate is 7%. And I think that is going to qualify for a TEA. So the investment amount, if it's in a TEA, is going to be $800,000. One of the big issues is going to be that total investment amount. So she applied saying she had invested 1.8 million, but as we said, that 500,000 is not going to count. So that drops us down to 1.3. Retained earnings is not going to count. So that money has to first be distributed to her. So she could have the $1 million distributed to her. She'd have to pay taxes on it. So that's going to end up being, 700,000 or whatever her applicable tax rate will be. But because she's in a TEA, she may qualify for the $800,000 amount if she takes those retained earnings, reinvests them into the business, and that 300,000 that she used to purchase shares of a business, if those $300,000 went to the E2 business and did not go to the seller, then she might be able to use those funds. So let's assume that she did, that the person that she purchased shares from continues to be a co-owner and said, hey, put the funds into the business and we are going to use those funds to grow the business. That should be fine for an EB-5 because they were her personal funds. They went into the business and then they went toward the creation of jobs. So if we make that assumption, then she's hired 5 employees. She needs to hire an additional 5. So she is going to need to show that she's going to hire an additional 5 employees. She doesn't have to do that before she applies. She can do that through a business plan, a very detailed business plan showing exactly what funds will be deployed by the business, when they will hire, what job titles those people will have, what they'll be paid, et cetera, et cetera. So the business plan does need to be robust, based on good assumptions. But with that, she should be able to satisfy the employment requirement. So a number of things to keep in mind if you're trying to move from an E2 to an EB-5 that highlight the rules at play for an EB-5. So finally, we have talked about a number of these issues as well. Some final things to be aware of. Timing considerations are significant for the EB-5. Again, that first step, the I-526, USCIS says it will take almost 5 years to decide that I-526. But huge benefit. If you're in the US and your green card category is current, then you can file the I-485 at the same time as the I-526, get your travel permit, get your work permit, and you have a lot of flexibility while that I-526 is pending. And then once the I-526 is decided, the government should then immediately turn to the I-485 to decide that. It will take them time to decide it, but they will have it if it's filed concurrently, and they'll move to adjudicate that. Travel considerations and visa expiration dates. Once you apply for an EB-5, again, I-526 is the first step. Once you do that, it is a signal to the government that you intend to pursue permanent residence in the United States. So that can create problems if you are relying on another visa. So for example, if you have an E2 visa in the United States, and let's say you decide to apply for an EB-5 and you choose consular processing, you'll file the I-526. When you apply to renew your E2, the consulate will see that you've applied for an EB-5, and each time you come into the US, they'll see you filed the I-526, and they may question you about your intent to leave the US at the end of your E2 status. So generally speaking, it's a good idea to renew your non-immigrant visa before you apply for the EB-5. Now, your intention when you renew the non-immigrant visa needs to be that you don't intend to adjust status based on that visa. So you can't do that. You can intend to apply for an immigrant visa at a consulate. So that is permissible. So just be ready to explain at the border or when applying for the visa, the non-immigrant visa, that even though you've applied for an EB-5, you are consular processing and intend to leave the country to get that. You do not plan to adjust status in the US, and you can mark that on the application to show that. And that is called dual intent. So basically, when you get a non-immigrant visa, an E2 say, that is not a dual intent visa. So your intent needs to be to leave at the end of it. An H-1B is a dual intent visa, which means that even though it's a temporary visa, it's not a green card, you can apply for a green card while you're on an H-1B, and you can come into and out of the country on an H-1B, even if you have a pending green card. Parallel green card strategies. There is no prohibition on applying for more than one green card. So for example, if you want to apply for an EB-5, but you also think you qualify for an EB-2, national interest waiver, you can apply for both and just see which one works out fastest. If you have a family member, say a brother or a sister who's a US citizen who wants to sponsor you, you can do that while you're applying for the EB-5 and just see which one works out faster. Or maybe the EB-5 is the option that gives you work and travel authorization, so you pursue that. So you can have parallel green card strategies, working for two or more options at the same time. And planning is really key. So you can tell the EB-5 is very complicated. It does help to talk with a lawyer about your plans, your goals, how to navigate this. We are very happy to talk with you. You can schedule a consultation on our website, either 30 minutes or an hour, and we'd be very happy to talk with you. But this really is a visa option that benefits from the help of a lawyer. EB-5s are complicated. All right, so a few questions have come in. The first, does the investment have to be a one-time investment, or can it be made over a period of time in multiple sectors? So in general, we do recommend that you invest the full required amount before you file the I-526. But if you want to invest, half of the investment now and half of the investment in a year and then file the I-526 after that, that is fine. But we do, again, recommend that that full investment amount be available to the business before you file. Now, again, you don't need to prove the job creation before you file the I-526, but you should show the investment amount is satisfied. When the investment is made, can we expect returns in the long run, or if the criteria is only job creation and not returns. So can returns be expected? It's okay for you to get a return on your investment. The problem is when you start getting into guarantees. So if your funds can be returned to you or you're guaranteed a return, that is where the USCIS will likely have an issue. So this needs to be an at-risk investment. So that means the possibility that you won't make any returns and possibly will lose your investment. Unfortunately, that is the nature of what USCIS is looking for. But in practice, if you use a good regional center, or if you're applying based on a business and you are a good business owner and manager, it is fine in general to receive a return from your EB-5 investment. But the job creation piece is a fundamental requirement. You must show that 10 jobs will result from your investment. If I'm a dual national, British and Indian, can I employ people from both of my nationalities? So I think you're a little confused in terms of the EB-5 versus E2. So the E2 is the visa that the business has the nationality of the E2 investor. So if you apply for an E2 visa as a national of the UK, you can then have nationals of the UK applying for E2 employee visas to work for that company. The EB-5 is not like that. So the EB-5 is a business in the US, and you need to be a permanent resident of the US or a US citizen to count as one of those 10 employees. So nationals of the UK or India, it's really irrelevant for purposes of employment. Um, uh, it is going to be relevant in terms of how long you have to wait for the visa, because if you were born in India and you apply for that unreserved category, so you're not in a targeted employment area, you will be waiting some time. But if you were born in the UK, you don't have that wait, so it would be relevant there. Can the business get EB-5 rather than individual? So a person gets an E2 investor, started a business, and then the business produces 800,000. Can the business apply for the EB-5? No. So you as an individual are the petitioner. The business is the new commercial enterprise. So these are defined legal terms in the law. So you need to have the $800,000. You need to put that $800,000 into the business, and the business needs to create those 10 jobs. So a business does not apply for an EB-5. And can you do a webinar on the EB-1? That's a great idea. I will share that idea. All right. Thank you all for your questions. Please keep an eye out for our email. We'll have a link where you can schedule a consultation with our firm, as well as a link to the webinar and a comprehensive guide on the EB-5, and a link where you can sign up for future webinars. So we do hope to see you on those. In the meantime, stay well, reach out if we can be of any help at all. Thank you so much.